All right, you're here, you're interested in finding out the three types of properties, specifically the three types of ownership of property, and more importantly, how do you own your specific deed? And the way we're going to do this is I'm going to give you the three types. I'm going to tell you what the pros and cons on each one are and what happens after you pass away in each of the three examples. The reason why we're doing this is to make sure that you own the property how you think you own it, and make sure that you know what happens to that property if you pass away. So let's go straight into it. The first type of property is the most common type of property held in specifically New York, where I'm at. Tenancy in common is the most common type of property ownership. The second one is joint tenancy with the right of survivorship. The third type of property ownership is tenancy by the entirety. Let's go to the first one. Tenancy in common is usually held when one or more than one person holds property together with no other indication on the deed. That means all you see on the deed is John Doe and Jane Doe own this property. Nothing else is said on the deed about the type of ownership that it's held. So by default, that type of ownership is called a tenancy in common. Why is that important? It's important because that means John Doe owns 50% of the asset and Jane Doe owns 50% of the asset. What's important about this is each of them own 100% of the property together. That means they both share responsibilities and liabilities when they come up. They both own one half of the property, but the entirety of the asset is owned by both of them. What happens when John Doe passes away? When John Doe passes away, that 50% interest will go through that person's will, if there's a will, or it would go through the laws of intestacy. For instance, if John Doe has a son, that property will go down to that son. If John Doe has no son, it would go up to the parents. And if he doesn't have parents, it goes to the siblings. Now, if John Doe and Jane Doe are a couple, they've been together for 30, 40, 50 years, and they own 50-50, most people would think that Jane Doe inherits the property when John Doe passes away. That does not happen because they both separately own 50%, and that 50% goes down to their children or through intestacy. Now, if John Doe leaves behind a will and he designates Jane Doe as the beneficiary, his 50% interest will go to Jane Doe. But it's important that you notice it doesn't happen by default. So the tenancy in common is the most common type of property ownership, and each one owns their individual share. So if there's three people, you guessed it, 33%. Each person owns 33%. So in this type of ownership, you see where individuals sometimes get caught in that ownership while somebody else does not want to sell the property. When that happens, what usually is brought is called a partition action in order to compel the sale of that property and compel the accounting of that property so that the distributions are fair and reasonable per the law of the state. The second type of property that is owned in New York is specifically called a joint tenancy with the right of survivorship. The main difference between those two types of ownerships are specifically when one of the two people pass away, Jane Doe and John Doe, when one of them passes away, the interest automatically converts to the other person. That means if John Doe passes away and they were together for all those years, automatically Jane Doe owns the property because she owns it with the right of survivorship. Now, joint tenancy with the right of survivorship needs to expressly come out on the deed. If it is not said specifically like that, joint tenancy with right of survivorship, if it doesn't say those specific words, the court may hold that the tenancy created was actually a tenancy in common. Remember, that's the default. If that's the default, you don't want to get caught up in a situation where you go into a deed thinking that you have this right of survivorship, but the words are not created in there. Now that person passes away and it goes down through intestacy or through the will. Instead, if those words are specifically included, now the property goes automatically to that survivor. It's important that you notice that if the interest is held 99% from John Doe and 1% Jane Doe, and they have a joint tenancy with the right of survivorship, if John Doe passes away, the property will convert automatically to Jane Doe because she has that right included in the deed. We want to make sure that when you do your will, your trust, or anything, any estate planning documentations, in order to bequest your property and devise your property after you pass away, you take into consideration whether the deed is actually held with the joint tenancy with the right of survivorship or not. The other provisions, insofar as ownership of the property, continue the same as a tenancy in common, generally speaking. So the main difference is that the surviving individual gains full ownership of the property by operation of law. No action needs to be taken into the court for this type of ownership. The third type of property ownership that is held is specifically called the tenancy by the entirety. This type of tenancy is more uncommon. The reason why it's more uncommon is because it has a precondition, which is specifically the two individuals have to be married when they go into this tenancy. That means if, for instance, the two individuals are married and now they go into the creation of the deed and they say John Doe and Jane Doe as husband and wife, that creates a tenancy by the entirety. Why is that particularly different than the other two? If there is a tenancy by the entirety, what happens is one person cannot sell their interest without the consent of the other person. Why? Because the law treats both of them as one person. That means if one person says no to the sale of the property, the other individual cannot compel the sale of that property. If there is a divorce, that tenancy by the entirety is broken. And when it's broken, it creates a tenancy in common, the first type. So when you see a situation where individuals are separated, the compelling of the action becomes very difficult because they still have a tenancy in common. Their divorce has not been finalized. There could be ways for attorneys like myself to create a partition action if there's a separation and there's some type of agreement in place, because that may break the tenancy by the entirety. But it's extremely important because the tenancy by the entirety creates a very powerful unity between the two individuals, forcing one person to need the consent of the other in order to sell it. This tenancy by the entirety also has a very similar feature to the joint tenancy with the right of survivorship, because when one of the spouses passes away, the property automatically goes to the other individual. So the surviving spouse gets everything by operation of law automatically, just like a joint tenancy with the right of survivorship. Why is all this important? Because if, for instance, specifically related to the third tenancy, if there's a divorce, then this means that the surviving children may have a claim to that asset because that created a tenancy in common. So when you see, for instance, a father or a mother remarry and then they had this property before, that created a tenancy in common because of the divorce. The divorce now means that the surviving children have a claim to that house through the laws of intestacy, unless that surviving spouse and that remarried spouse create a will and or a trust. So there you have it. You have the three types of property ownerships. The first one is the most common, tenancy in common. If you look at your deed and you have two people on it, and one person, second person, with nothing else being said on the deed related to the specific words that I'm using, you have a tenancy in common. That means the property will go down to your heirs or your beneficiaries if you have a will. If you have on their deed, specifically related to the joint tenancy with the right of survivorship, you know that if you survive, you're going to get everything. But if you pass away before, that other person is going to get everything. And if you have a tenancy by the entirety and you are currently married, that means your surviving spouse would automatically inherit that property after you pass away by operation of law, just like that. You can also stop that person from selling that asset. That is the power of law. And just so you know, if you're interested in assessing your specific deed and you want to make sure that your estate plan actually does what you want it to do, schedule a call. We'll give you a free discovery call. The point of it is really to empower you with advice so that then you know what are your options to make sure that the people you love actually get the property how you want them to. Take care. Bye.